And it's a pleasure to be with all of you. It's Tuesday afternoon here in New York City. It is bright and sunny, and it's starting to feel like summer down here. You'll have an opportunity to hear from both myself here in the city, as well as Nicole Price, who is another attorney in our New York City office. And then in the program, you'll also be hearing from two of our Buffalo-based attorneys, Seth Gilbertson and Kevin Cope. And we're really excited to bring you the program. And Kathy, if you would go to the next slide, please, I'll walk everyone through it. So I'll be with you for these next 10 or so minutes, and I'll make sure to cover where we are with COVID, of course. And before that, give you a brief introduction on who I am, because I'm delighted to be hosting this series as your new co-host. And then after that, we'll get to Seth, who will talk about internships in 2022, Nicole, who will be talking about AI, and then Kevin, who will be addressing the special duty doctrine in the context of malicious prosecution. We'll make sure to have some time at the end, around 12:40 or so, for any questions that you may have, and we'll do our best to answer them. But for now, if Kathy, you'd go to the next slide, I'd like to shift gears for a minute, please, because there, of course, was a tragedy in Buffalo over the weekend, and our firm is part of the community, and we are deeply, deeply just saddened and dismayed. And our management committee, Kevin Bernstein, issued a statement yesterday about essentially Bond's position on how we move forward from this and acknowledge the pain and suffering in our community. So I'm just going to read briefly from that, and please trust it comes from Kevin's heart and ours more broadly at the firm. So as Kevin wrote yesterday, there are no words to fully describe the horror of the shootings in Buffalo this past weekend. Innocent lives were taken in what is believed to be a hate-fueled act of extreme violence. Many pundits are speaking about the toughness of Buffalo's citizens, and we here at Bond certainly know that to be true. But an act of violence such as this, believed to intentionally target our Black neighbors at a grocery store, a place so many of us frequent without a second thought, can shatter a community's sense of safety and place. For many residents of the Buffalo region and for Black communities across the country, this act of violence creates additional trauma well beyond the crime scene. Grocery shopping while Black seems to be a dangerous experience. Taking the subway while Asian appears to be unsafe. Going to your synagogue while Jewish may be hazardous. Walking through your neighborhood as a member of the LGBTQ community can be perilous. The hate and violence must stop. And please trust that everyone here at Bond really believes that to our core. Next slide, please, Kathy. So let me tell you a little bit about me, because we didn't have a chance to more fully walk through that when Andy passed things over to me 2 weeks ago. And just so all of you know who have not yet had a chance to work with me, I joined Bond last year. And before that, I was with the trade association, the Continuing Care Leadership Coalition, which is nested within the Greater New York Hospital Association family. And I focused in my work there on ties between hospitals and healthcare systems, working in long-term care and human services. Core issues that I've addressed there, and as well in other portions of my career, include healthcare transformation and strategy, human service and healthcare ops, crisis management, legislative and regulatory affairs. And before that, I was in city government for a stint in New York City's mayor's office under Mayor Michael Bloomberg, as well as agency chief of staff. And I've done work in the nonprofit setting as well. And I bring all of that to Bond in service of our clients. And if Kathy, you go to the next slide, I'll just give you a snapshot of an area where I have some experience that is certainly relevant. Cybersecurity is, of course, pertinent and elevating in the ways in which it captures our attention, the pandemic in no small way contributing to that. And before the pandemic, I, as just one example, led an exercise of about 150 healthcare providers here in New York City to help boost their cyber readiness. And that involved key federal, state, and city partners at the agency level. And that work continues. If Kathy, you go to the next slide, please. I continue to be part of the community at the intersection of cybersecurity and healthcare and its meeting places with data privacy. The key nexus point right now is at the federal level through Health and Human Services, what's called the 405D working group, which is a public-private partnership concerning healthcare cybersecurity and data privacy readiness. And you can see on the slide how the mission of the group is more fully described. The group has plenty of material out there, including what you can find at the bottom of this slide is just one example for smaller healthcare organizations. And what is also important for you to know is that there are plenty of bond attorneys, I'm one of them, and there are others, of course, you can reach to in order to ask your questions about cybersecurity preparedness and the regulatory as well as other operational ways in which you can stay ahead of the game. So if you, Kathy, please would go to the next slide, we can shift gears. And I'm going to quickly walk through some COVID information. Unfortunately, the news isn't great these days. If you go to the next slide, please, Kathy, I'd appreciate it. If you look at the picture nationally, there has been a 14-day change of about 61% in terms of overall cases. And we've reached the grim milestone of 1 million deaths nationally. We also are getting word, really breaking last evening, that the public health emergency, which was set to sunset on July 15th and which ostensibly still could, federal government is leaning very strongly toward extending it again because, of course, we're not out of the woods yet. And so we'll keep track of that and we'll keep you posted. Next slide, please, Kathy. COVID hotspots, as you can see, are really concentrated, particularly in the Northeast, as well as in the Midwest. And some of this, as we've talked about on this webinar, is about who's reporting what with more home tests and antigen tests in particular. Government bodies aren't getting all the data, but this gives you a flavor of what's happening across the country. And in the Northeast, we're definitely seeing an uptick where I speak with you from. Next slide, please. And in New York City, it is similarly getting a little bit more elevated in the attention that we're giving to COVID relative to the months that preceded, where even just yesterday, Mayor Adams indicated that it strongly recommended that individuals begin to wear masks again indoors. The state and the CDC have also issued comparable recommendations. Let me be very clear that none of this is a requirement at this point. And so we're not stepping back in to where we were a few months ago through the various federal and in particular state regimens around this. But the numbers are not trending in the direction we'd like, and we're watching it all closely, and we'll keep you posted. Next slide, please. And here's just some more in terms of the 2-week picture as between May 9th and today. And what you're seeing are case averages that are ticking up. We're about 500 more across the state than we were even just 2 weeks ago. Next slide, please. So let me just allow us to shift gears mentally. And I want to just remind you as well about the Workplace Investigations Forum that Adam previewed with all of you during last week's webinar. It's taking place on June 9th at the DoubleTree by Hilton. Adam will be leading it along with Bond colleagues. You can register at the link I embedded in this slide. And I hope that anyone who's in the Syracuse area and interested in attending signs up right away. And with that, let me shift to introducing our next speaker, who is Seth Gilbertson. Seth joined Bond recently himself, and we're delighted to have him. He brings a tremendous amount of experience in education, as well as, like me, he's worked in government and other applied settings, and has a lot to tell us about what it is as we move into the summer. Interns are coming up, and we've got to figure out how best to manage them. It is not like it used to be, and we're going to hear from Seth exactly what you all should be thinking about. So Seth, the floor is yours. Please take it away.
Thanks, Gabe. Longtime listener, first-time caller here today. So I appreciate you having me to present. As Gabe said, heading into the summer, a lot of internship programs run over the summer. We thought it'd be a good chance to do an update and talk to some folks about their internship programs, make sure that we've thought through some of these programs that have maybe been around for a long time, but we haven't necessarily evaluated them recently in light of some legal changes and old principles as well. Next slide. So there are lots of different types of applied learning or experiential education programs. Mostly the legal principles apply evenly across the board to them. The sort of sector that you're in or the nomenclature that you use with regard to a particular program usually doesn't matter. There are some exceptions to that, but for the most part, the laws apply equally across the board to these different types of programs and more that are not listed here. I'm going to talk generally about internships today because it's a broad category and gives us sort of a baseline to work with. Next slide, please. Oh, there, see, internships. I often describe a successful internship program as sort of a three-legged stool with the student, the placement site, and the educational institution, the college or university usually being sort of the three legs to that stool. And while it's important to know certainly your own role and where you fit in that structure, it's also important to communicate with the other pegs of the stool, if you will, so that all three can work together in concert to uphold the successful program. Next slide, please. I'm primarily going to focus on educational institutions and the business and nonprofit entities that usually act as placement sites. So one of the biggest things legally that we often talk about, especially if you're running unpaid internship programs or similar types of programs, are whether you're doing that appropriately, whether you have to pay, whether you've structured a program in such a way as to be able to have an unpaid experience, primarily for the benefit of the intern. And that primary benefit really is the test. Since about 2015 or 16, the federal courts started applying the primary beneficiary test pretty widely. In 2018, the Federal Department of Labor finally caught up and got rid of its old 6-part test and adopted what was already sort of the standard in the courts, which is the 7-part primary beneficiary test. There are seven sort of considerations within that test, but none is controlling. You're supposed to evaluate it, sort of looking at all these factors to determine what the courts say is the economic reality of the program. What they really mean is who benefits the most, who's the primary beneficiary of the relationship. In order for it to be an unpaid experience, that ought to be at the conclusion of your running through the 7 parts. You ought to conclude that the intern is the unpaid intern is the primary beneficiary of that. Now, I'm not going to go through each of these 7 pieces because to do so would basically be an entirely separate presentation. But we will be providing the slides. Look at those. If you do have an unpaid program and you haven't evaluated with your counsel, I would strongly encourage you to do so. Next slide, please. Here are the other 4 parts of the federal primary beneficiary test, but again, these slides will be available. Next slide, please. And of course, New York State, not to be outdone, has its own test under the New York State Department of Labor to determine whether an unpaid internship experience is appropriately unpaid or should be a paid experience. And of course, not to be outdone again, there are 11 pieces to the New York State test, which is labeled the employment relationship test. Not very imaginative there by New York. There are different rules for nonprofits. We're talking primarily about for-profit host sites. Next slide, please. And again, I'm not going to go through all of these steps, but you will be able to see them in the slides. And again, especially if you're in New York and you have an unpaid internship program, you're operating one, it's a good idea to get that evaluated. If you haven't evaluated in a while, even if you did, 5-10 years ago, it's a good idea to reevaluate it because some of these have changed a little bit. Their interpretation has changed a little bit under the federal standard. The actual test has changed. And the programs tend to evolve over time. So you want to make sure that you're applying the test to the program as it exists now, not how it was, 5 or 10 years ago. Next slide, please. Shifting gears just a little bit here. Without looking at the test, there are a couple of other exceptions that some entities can use in order to run and to appropriately run an unpaid internship program. In the government and not-for-profit sector, you can have volunteers. There's no such thing as a volunteer in the for-profit sector. So be aware of that. The focus of a volunteer program, an appropriate volunteer program, should be a civic, charitable, or humanitarian cause. I would add educational to that as well, although that may be sort of included in civic. It cannot be paid. It's sort of an odd aspect of it that you can't pay a little bit and call it a volunteer program. Once remuneration is received by the intern, it's a paid program, and the payment has to then be minimum wage. That said, you can cover expenses, transportation, room and board, things like that. So as long as nobody's sort of benefiting or getting paid for it in addition to their expenses, it can be appropriately still deemed a volunteer program. Volunteer program can't displace regular employees. And an employee can't volunteer to do their own job. They can volunteer to do a different job for the same organization, but you can't have someone who gets paid during one part of the day and not paid during another part of the day. Another exception that I want to briefly mention here, and this is primarily for our college and university clients, is the educational exception. That is not a written exception. You won't find it in regulation or in a statute anywhere, but it is as applied by the enforcement agencies that you see that programs like orientation leaders, student orientation leaders, resident assistants, RAs, sometimes GAs fall into this category as well, where they receive something like room and board or discounted tuition, something like that. Team managers, maybe, the basketball team manager, something like that. It's an unpaid position. You want to structure it so that it's integrated into the academic program of the student, usually on campus or closely related to extracurricular activities. And that if there is any support like tuition, or room and board, that those are things that are associated with the educational program and offset costs to the student's education. Next slide, please. And then finally, there are some insurance requirements. One of the most common misconceptions, I'll call it, is that an unpaid intern does not have to be covered under the site's workers' compensation insurance. One of the weird things we see in this area of the law is that employment is defined very differently under different laws. So someone can be an employee under workers' compensation law, but not an employee under the Fair Labor Standards Act, or even the New York State Department of Labor test. So we want to look closely at the particular law that we're looking to apply. In the case of workers' compensation, an unpaid intern is almost always required to be covered because the Workers' Compensation Board considers the experience that and training that the intern receives, the educational component of that, to be a form of payment under the workers' compensation law. There are a few exceptions for nonprofits who have non-manual types of unpaid volunteers or interns. But I will say that's a very narrow category because the Workers' Compensation Board considers dusting and carrying of pamphlets to be manual activities. So trying to find something that's non-manual that fits into that exception is pretty hard to do if you can't, pick up a feather duster without it becoming a manual activity. So that's something you want to look at closely. Liability coverage. When you have people on site at your place of work, you want to make sure they're covered by your liability policies. If you are relying on a liability policy that is carried by a college or university, which is fairly common in these areas, you just want to make sure you are meeting the requirements of that. Oftentimes, it is that the position is unpaid, that the student receives credit for it, that there's a written agreement, for instance, between the site placement, the placement site, and the college or university. And then finally, if you have interns that are out there operating your vehicles, you want to make sure that they fit into the class of individuals who are covered under your automobile policies. Next slide, please. Real quickly, a couple other regulatory considerations that you should look at, and most of these are well understood because we all understand that we can't discriminate against individuals regardless of whether they're paid or unpaid. That's explicit in the New York State human rights law that became part of the law in, I believe, 2014, where it specifically applied to paid and unpaid internship types of programs, and they're essentially covered the same as employees. The ADA applies to almost all internship types of situations. One of the things you want to look at closely, especially if you're applying any kind of technical standards, is that you have the acceptance separate from the accommodation process. So you're not looking at an individual's potential disability issues as part of their application to the internship. And then you want to do a case-by-case individual assessment, just like you would with an employee or even a visitor in some situation. Title VII is a little different. It only applies to compensated employees. But again, we have New York State human rights law that applies to paid or unpaid. So it's kind of a non-issue. And then finally, hate to say this, but there are some cases out there that apply Title IX to site placements, particularly in the health sciences fields, where there's a very close relationship between, for instance, a hospital and a medical school or something like that, where they're really integrated program, and courts have applied Title IX to what we would consider a non-educational entity like a hospital or other type of healthcare association. Next slide, please. So just to recap, where you fit into that stool matters, but you want to understand where the other legs, the responsibilities of the other legs as well, and make sure that those lines of communication are open so that they can coordinate appropriately in order to make sure that the program is successful. And if you haven't looked at these programs in a while, now's the time to do it, especially as we're going into summer. Maybe you want to do in advance of a fall program that you're offering. With that, I will pass it on to Nicole.
And let me say thank you, Seth. What a terrific presentation. You have gotten a number of questions in the chat, and I trust that you'll be able to answer them over the course of the coming presentations. Clearly, people are interested and are wondering how it applies in their places of business. So, Seth, thank you. Nicole, let me turn to you now. I'm delighted that you can represent our New York City office, and further, we share in our background that both of us went to law school at Fordham, though you joined our firm from Putney, which was a firm that had been, of course, independent and then merged with Bond last year. You're focused on labor law, and you've got information to share about artificial intelligence, which is exciting. Looking forward to hearing what you have to say. So, Nicole, the floor is yours.
Great. Thank you, Gabe, and thank you for that introduction. Good afternoon, everyone. I'm very pleased to be joining you today on this webinar. As some of you know, the use of AI, software, and algorithms in recruitment, hiring, and promotions has become increasingly popular. Many use this technology to aid in the elimination of bias in hiring and promotional processes, as well as employee performance reviews and things like that. However, these technologies can also be used to perpetuate unconscious biases or have a disproportionately negative impact on protected groups. So today I'm going to talk a little bit about New York City's new law regulating the use of automated decision tools, including AI, and also touch upon the EEOC's new guidance on this issue. So turning first to the New York City law, this law regulates employer and employment agencies' use of automated employment decision tools to make employment decisions regarding any candidates or employees residing in New York City. So automated employment decision tools refers broadly to any computational process, including AI, which is used to assist or replace discretionary decision makings. I'll refer to these as AEDTs or decision tools. And then employment decisions is specifically referring to the screening of candidates for employment or the screening of employees for promotions. And this new law takes effect January 1st of 2023. And there are two main components to it. The first is a bias audit of your decision tool, and the second is a notice requirement. So next slide, please. So this is the full definition of automated employment decision tools that's in the statute. It's a little bit bulky, but as I said, I kind of simplified it down for you before, but this slide is here just so you have the full definition. And next slide, please. So turning to the bias audit requirement, under the new law, employers can only use decision tools to make employment decisions regarding candidates or employees if the tool has undergone an bias audit within the last year, and the summary of the results of that audit and the distribution data are publicly available on the employer's website. If these two components aren't complete, then it's unlawful for the employer to use the decision tool on a candidate or employee who resides in New York City. And then you also have the definition of a bias audit there. And the important part is that the audit must include testing to assess its disparate impact on protected categories. And this is something that if you use AI or other automated decision tools, you can have your audit and should have your audit conducted this year as the new law goes into effect January 1st of 2023. So if you're planning on using it next year, having the audit done in the next few months is what we're recommending. Next slide, please. So then the notice requirement has two subcomponents. First, at least 10 days before using the decision tool, an employer must notify an applicant or an employee, if we're talking about a promotion, of two things. First, that an AEDT will be used to assess the candidate or the employee. And second, the job qualifications and characteristics that the tool will use in conducting the assessment. So importantly, an employer must allow a candidate or employee to request an alternative process or accommodation with respect to the use of the AEDT. The law is silent on the employer's obligation to provide an alternative or accommodation, but we know that if the request for an accommodation is due to a disability or a religious practice, you're going to need to take steps to comply and provide an accommodation in accordance with the American with Disabilities Act, the ADA, or Title VII, as well as New York State human rights law and New York City human rights law. Then the second requirement is that the employer must disclose information about the type of data collected, the source of the data, and your data retention policy. To comply with this requirement, the information can either be posted on the employer's website, or the employer can provide the information to a candidate or employee after they receive a written request. So there's two ways to comply with that. And then next slide, please. There are civil penalties for any employers who violate the law, which we typically see. And this is just a brief outline of those penalties. And that pretty much summarizes the new law on AEDTs, including AI in New York City. And again, this applies to employers who are hiring or promoting individuals who reside in New York City. So if you have employees who are living here and working remotely for your organization, then this law might come into play for you. And then next slide, please. And then for all employers, we have who are impacted by the ADA and Title VII. We have the EEOC's guidance on AI and similar technologies. The EEOC released this guidance last Thursday, so this is very recent. And in it, it talks mostly about the interaction between AI and the ADA. And in it, it provides several examples of how employers' use of AI may be violating the ADA. And some of these examples are listed out here on this slide for you. And one example that's in the guidance that I thought was particularly helpful is that an employer may be using an algorithm that rejects applicants who have a large gap in their employment history. And if a particular applicant has a gap in their employment that's caused by a disability, for example, they were undergoing treatment and they were out of work for that, then the algorithm would screen out that applicant because of their disability, which would be in violation of the ADA. So those are the types of issues that this guidance addresses, and also relates back to what the New York City law was trying to get at with the bias audit, to make sure those types of screening out processes are addressed. And then, similar to the requirements in the New York City law, the EEOC recommends that employers provide information to applicants about the AI or automated decision tools that are being used to assess candidates, the characteristics that are being assessed by the tool, and how to request an accommodation. So those are the main components of AI right now. This is certainly a hot topic, and I think we'll be seeing more of it in the future, and possibly a New York statewide law addressing this issue in the next couple of years. But that concludes my presentation. I will pass it over to Kevin.
Nicole, thank you. That was really informative, and you really focus on an important point at the end, which is that New York City sometimes ends up being a bellwether for what we see in other corners of New York State, and even across the country. So we'll be watching this issue closely, and thank you for taking the time to bring all of us up to speed. And with that, let me turn to Kevin, who is back on the webinar. Kevin has been a presenter previously, and just for those of you who wish to know a little bit more about him, he's with our Buffalo office, and he focuses on commercial litigation and municipal defense matters. And he's here to tell us about some issues concerning special duty doctrine and malicious prosecution. Kevin, we're really delighted that you're with us. The floor is yours, and thanks for bringing us all up to speed on what you have to share.
Thanks, Gabe. Just to shift gears a little bit now, we're going to be talking about the special duty doctrine and malicious prosecution. So as many of you can probably tell, I'm speaking more directly to the municipal actors out there. So the towns, the villages, the counties, the cities. So two decisions recently came out from the New York Court of Appeals, as well as the U.S. Supreme Court, relating to those two doctrines that largely impact policing issues within municipalities. The first relates to the special duty doctrine. And just to give a brief background on the doctrine, the special duty doctrine applies to negligence actions against municipalities, and it is necessary for a plaintiff to satisfy the special duty doctrine where the government is acting in a governmental capacity as opposed to a proprietary capacity. And proprietary functions are largely traditional and private enterprise functions, such as maintenance of land, operation of parks, building roads, that kind of thing. A governmental function is more of a protective function and largely applies to general police powers, which would include fire protection, issuing permits, garbage collection, policing, those kinds of things that the state or the municipality does within its general police powers for the protection of citizens. Whereas where it's a proprietary function, the normal rules of negligence apply, and there's no special duty that the plaintiff must satisfy before being able to bring suit against the municipality. However, where a governmental function occurs, the special duty doctrine must be satisfied. Next slide, please. The reason for this is because municipalities owe a general duty to all of their citizens, and a citizen cannot use this general duty to satisfy the necessary elements of a negligence claim, because there's no direct duty running from the municipality to the citizen. There's just a general duty owed to everyone. A special duty, however, creates a direct connection between the plaintiff and the municipality that allows for that duty to be created to satisfy a negligence claim when the municipality is acting in its governmental capacity. And there are three specific areas that the courts have defined when a special duty runs from the municipality to the plaintiff. The first is where there's a statute that expressly creates that duty. The second is where the government voluntarily assumes a duty through a direct connection to the plaintiff. And the third is where the municipality takes control of a known dangerous situation that would create a duty to all those involved in that dangerous situation. The voluntary assumption of a duty is the most common version of when a special duty is created between a municipality and an individual plaintiff. In all of these cases, there is a large defense that municipalities have, the governmental function immunity, which basically holds that where a governmental actor is acting in some form of authority that requires the exercise of discretion, that they can't be required to make a correct decision every single time. And so where someone makes a discretionary determination, that can still be a defense to a negligence action, even if the special duty doctrine is satisfied. Next slide, please. And this came to a head with the recent decision in Ferrera versus City of Binghamton that was decided by the New York Court of Appeals in March. The plaintiff was shot during a no-knock warrant of a residence where the police were monitoring the residence, determined that a dangerous felon lived at the residence, and then they call it a dynamic entry. It's another term for a no-knock entry, where they entered the residence, and the plaintiff, who was not the subject of the warrant, was sleeping on the couch, and when he got up, he was shot when he got up from the couch. He brought a suit against the City of Binghamton, claiming that the police were negligent in their entrance of the residence, and his damages resulted from that negligence. And the Court of Appeals, looking towards the facts of this case, made a few key holdings. The first was that the plaintiff was arguing that the special duty doctrine only applies for passive municipal negligence, where the municipality was actively negligent. The plaintiffs were trying to argue that the special duty doctrine does not apply. However, the Court of Appeals rejected that and stated that it applies to both passive and active negligence on the behalf of a municipality. In general, however, they stated that a no-knock warrant does not create a voluntary assumption of a duty. However, it falls within that third subset of special duty doctrine, where they take control of a known dangerous situation, and therefore all persons within the residence that is subject to a no-knock warrant can satisfy the special duty doctrine if they are injured in the event of the no-knock warrant. Essentially, this holding appears to state that the special duty doctrine is satisfied whenever there is a no-knock warrant, and there is certainly going to be significant litigation following this decision to clarify that holding. Next slide, please. The next case relates to the Supreme Court's case relating to malicious prosecution. And as some background for malicious prosecution, there are three elements for a malicious prosecution claim to be brought. And these have typically been developed through state laws in each of the various 50 states, but they all generally seem to be the same. It's that there's a suit or proceeding that is instituted without probable cause with some sort of malicious motive, and that ultimately resolves in the plaintiff's favor. The favorable termination element, which is the last element, has been subject of a circuit split, where some circuits merely require that the prosecution end without a conviction of the plaintiff, and some requiring that there be some affirmative indication of innocence. The Second Circuit has long held that a plaintiff is required to establish some sort of indication of innocence in order to proceed with a malicious prosecution claim against a municipality. Next slide. And this came to a head in the Supreme Court's decision of Thompson versus Clark, which was decided in April of this year. And there, the plaintiff was arrested after his sister-in-law falsely stated that he was sexually abusing his one-week-old daughter. The plaintiff did not want to allow the police into his apartment. The police ultimately forced their entry into the apartment, arrested him, and charged him with with obstruction of justice and resisting arrest. However, before his case was called, the prosecution made a motion to dismiss the charges without explaining why they were seeking to dismiss the charges, and the judge granted that motion without putting any reason as to why he was granting that motion. So as a matter of law, under the Second Circuit precedents, the plaintiff could not establish a malicious prosecution claim. Next slide, please. The Supreme Court, however, disagreed, and what they established was that a plaintiff does not need to show that a criminal prosecution ended with an affirmative indication of innocence, but rather that a plaintiff need only show that the prosecution ended without conviction. And there are two important aspects of the Supreme Court's holding here. The first is that this is the first time the Supreme Court has affirmatively stated that a malicious prosecution claim arises under the Fourth Amendment. Previously, it had not defined which amendment it arose under for purposes of 1983 litigation. And what the Supreme Court did here is that they looked towards state law decisions on malicious prosecution at the time 42 USC 1983 came into existence back in 1871. And what they found there was that there was no indication across the board that an affirmative indication of innocence was necessary to establish a malicious prosecution claim. There is an important notes within the dissent for this case as well that might be the subject of further litigation. And the first is that the dissent outright rejects that a malicious prosecution claim can arise under the Fourth Amendment, and it dismisses the majority's what it called a hybrid claim under the Fourth Amendment, where it kind of combined false arrest with the malicious prosecution claim, and essentially states that the court should just state that malicious prosecution claims don't arise under constitutional amendments, but merely arise under state law, and it should basically have left it out of 1983 litigation in its entirety. So those are the important developments with respect to the special duty doctrine and malicious prosecution.
Okay, well, we are really excited, Captain, to have heard from you. We thank you for the time, and we look forward to having you back. And right now, I'm opening the floor to your questions. We've been answering them in real time through the chat as we've been receiving them. So feel free to enter any that you haven't yet. And let me also take this time to remind you of the event that Adam was mentioning to all of you during our last convening a week ago. The registration for that should be out through the chat function as well. Take a look there. And we're getting one more question, which we will take offline and answer. In the meanwhile, we want to just make sure that all of you know that we're here. Your bond attorneys are ready to answer whatever questions that you may have over the course of this coming week. And we will be back with you in a week's time. Adam will be hosting, and I will be your host on the 31st. Have a terrific afternoon, and thanks to everyone for your time.